Start. On the other hand, learned advocate for the respondent submitted that the land situated in a joint ownership land and no power of attorney is given to anyone by respondent, but they by undue advantage of respondent got the power of attorney executed on 7/12/2007, and thereby the land of the respondent who were poor persons have been used for road without there being any sanction of the collector under section 73 of the code 1879. Stop. It was further submitted that the petitioners have duped the respondent by giving assurance of permitting to use the road constructed by them on their land, and also assurance was given for house as well as money for regularization. Stop. It was submitted that the petitioners are using the land as a road without obtaining any kind of prior permission only on the pretext of easementary rights. Stop. It was submitted that there is no question of any easementary rights, and hence the SSRD has rightly allowed the revision application of respondent in view of the breach of the provision of section 73 of the code. Stop. Para. It was submitted that the petitioners without any consideration have usurped the land of the respondent by constructing a 60 feet wide road. Stop. It was submitted that even wire fencing was made along the road, drainage line is laid down, and thereby the respondents are being harassed. Stop. If the definitions are viewed together, it is plain that they do not tell us what immovable property is. Stop. They only tell us what is either included or not included therein. Stop. One thing is clear, however, that things rooted in the earth, as in the case of trees and shrubs, are immovable property, but within the General Clauses Act and the Transfer of Property Act, but in the later standing timber, growing crops and grass through rooted in earth are not included. Stop. Of course, these growing crop and grass from the subject matter of the sale of goods and standing timber comes within the last part of the definition of goods in the Indian Sale of Goods Act to the subject thereto if the condition about serving mentioned in the definition of goods exists. Stop. We have only to consider whether the instant case falls within the clause because it is out of question. Stop. The learned judge has held that it falls within the clauses. Stop. Here also the very first condition which is required to be fulfilled is that the immovable property as such has to be transferred or bequeathed, and creation of lease in my opinion would not amount to such transfer as is contemplated in section 13. Stop.